The founders are the men and women of the founding era, mostly men. The framers are the men who met in Philadelphia in 1787 at the Constitutional Convention and those who met at the state ratification conventions. They can be both, depending on what individuals or what meetings we're talking about. Anyway, just a side point. So not only did the framers put this language in the Constitution, on September 15th, before they left, Constitution Day is September 17th. It's Monday. September 15th, 2 days before they closed, this provision had not been added to the Constitution. And George Mason stands up at the Constitutional Convention. He's alarmed that Congress would have the sole power, the only power, to propose amendments. And he continued to insist on state authority to call for these amendment conventions. And in James Madison's notes, he records it this way. Colonel Mason thought the plan of amending the Constitution exceptional and dangerous because, you see, it only had Congress proposing amendments. As the proposing of amendments is in both the modes to depend in the first immediately and in the second ultimately on Congress. No amendments of the proper kind would ever be obtained by the people if the government should become oppressive, as he verily believed would be the case. So they added the language. Gouverneur Morris of Pennsylvania and Eldridge Gerry of Massachusetts both moved to amend Article 5 to require, I'm reading from Madison's notes, to require a convention on application of 2/3 of the states. This is in the Liberty Amendments. One of the things you'll get out of the books I write, particularly this book, the Liberty Amendments, is an enormous education about the Constitution, about the founding era, about what happened at the state conventions. I'm going to introduce you to people you've never heard of before, and yet during their time, they were crucially important individuals. Enormously important individuals, highly respected, which is why they were delegates to these various state conventions. And I don't think you're going to find it anywhere else. Unless you look at my dining room table on my social sites and see the various places you have to go. And I would encourage you to do that too. It can be fun. At least it's fun for me, but then again, maybe I'm boring. But the gut of this book, the guts of this book, is 200 pages. Then I have the notes and so forth for you to go check some information out if you want. One fella actually found a little error that we're going to have to replace, but nothing of significance. So you'll get an understanding of the Constitution, of the process, in plain English. Those of you who've read it know what I'm talking about. If you go to Amazon.com, look at the comments. We have 5 stars. No book gets 5 stars. Maybe the Bible. So Mason takes his stand. Morris of Pennsylvania, Gerry, Massachusetts, move to amend Article 5, and they do. And now we are told, ignore it. It's dangerous. Don't do it. When it's the only recourse we have. Federalist 43, after the Constitution is adopted at the Constitutional Convention in Philadelphia, it's sent to the states for ratification, and the national debates begin. The Federalists and the Anti-Federalists, some people in between. It's very interesting, those of you I hope who are still listening. The Federalists were actually the Anti-Federalists but they took the name Federalist. A Federalist is a quote-unquote states' rights supporter. That's what federalism is all about, a recognition of state authority, state sovereignty, not exclusively, but significantly. So even back then, they understood the importance of language. So really the anti-federalists became the Federalists, and the Federalists became the anti-federalists. All right, that's a side point. Mr. Producer, is this interesting to you? So while they're duking it out, as you know, these Federalist Papers, they're a collection of arguments made by John Jay, he wrote the fewest number, Madison, and Hamilton in support of the Constitution. There were also anti-Federalist papers. And I cite them in the book, too, just to give you a perspective. And what's interesting about both sides is that they believed in liberty, they believed in the sovereignty of the individual, they believed in plenary power for the states, they believed in checks and balances and divided government, they believed in enumerated specific powers for the various branches of the federal government, they believed eventually in the first Congress when it would meet, proposing amendments to further elaborate on the protections of the individual vis-a-vis this new central government. In other words, fundamentally, they shared the same belief system, the same value system. What they were largely fighting over was whether or not this document, as presented to them in the states, would do what they hoped it would do. Not exclusively, but largely. So in Federalist 43, Madison, talking specifically about this Article 5, and specifically about the state convention process, he says, it, moreover, equally enables the general and the state governments to originate the amendment of errors, as they may be pointed out by the experience on one side or on the other. And what I'm saying, ladies and gentlemen, is all wisdom in America is not possessed by members of Congress. As a matter of fact, very little of it is, based on their own record. So the notion, and even some conservatives foolishly cling to this, the notion that only Congress should propose amendments, not state legislatures, is foolhardy. For the reasons Mason said, for the reason the framers believed. But of all people, in Federalist 85, Alexander Hamilton, trying to fend off the anti-federalists because the Constitution looked like it was going to lose in Massachusetts, in New York, in Virginia. To fend off the anti-federalists and the critics, Hamilton specifically points to Article 5, and he specifically points to the state convention process. And he says, among other things, he explained, quote, the national rulers, whenever 9, which was 2/3 back then, 2/3 of the states concur, will have no option upon the subject. The 5th article, that's Article 5 of the plan, the Congress will be obliged, quote, I'm quoting his quote, on the application of the legislatures of 2/3 of the states, to call a convention for proposing amendments. This is Hamilton's language. A convention for proposing amendments, which shall be valid to all intents and purposes. He's quoting the Constitution. As part of the Constitution, when ratified by the legislatures of 3/4 of the states, or by conventions in 3/4 thereof. So here's Hamilton writing the nation, challenging the anti-federalists, and he's saying, you states have power. This convention process for proposing amendments. And then he goes on. And he says, the words of this article are peremptory. That is, the Congress shall call a convention. Nothing in this particular is left at the discretion of that body. And of consequence, all the declamation about the disinclination to a change vanishes in air. What he's saying is Congress can't stop this process. And what Madison was saying earlier is this process should assure you that the states, should the government turn tyrannical, can act. So we have Mason at the convention. We have Madison in the Federalist Papers. We have Hamilton in the Federalist Papers. And there are others. See, folks, the people who wrote your Constitution and adopted it, states that ratified it, they didn't put government above country. They put country above government. Well, Mark, if we have this convention, and these amendments that you're going to talk about in a moment are adopted, what's going to cause the federal government to comply with this if it's not complying with our existing Constitution? Isn't that an interesting question? Well, because the reforms I propose, these amendments, give the power to the states, the state legislatures in particular. So as an example, if 3/5 of the states override a federal statute, it doesn't matter what the federal government thinks. The states are not going to comply with them, and neither are we. In other words, the decision-making process has moved away. The ultimate decision-making authority is not with the Supreme Court in every instance. It's not with Congress in every instance. It's not with the bureaucracy of the president in every instance. In those instances where 3/5 of the states get together, 30 states, it's with them. It's with them. There's a gentleman who wrote a piece. These get sent to me. I don't really find them on my own. In the Hill newspaper, I don't even know if I can find it in time. But he says this Mark Levin comes up with these amendments. Talk about utopianism. Wants to rewrite the whole Constitution. Well, folks, first of all, the whole Constitution has been rewritten in many respects, and it's being rewritten today. I don't want to rewrite anything. I want to embrace the framers' intent, which is why these amendments that I propose will be fought tooth and nail, hammer and sickle, by the left and by the statist Republicans. But that aside, just to show you how ignorant our opponents are, I don't pretend to be James Madison or any of these folks, but I read what they give us. I listen to what they said to us. I look at what they did. Madison came to the Constitutional Convention better prepared than anybody else. He'd spent months preparing. He came with his own proposals. He'd even done some lobbying before the convention. Roger Sherman in Connecticut, same thing. The Connecticut plan was the plan that suggested a bicameral Congress, which was a very unique idea, although it existed in history, but not recent history. And then they debated over what this so-called House of Representatives, we call it today, and the Senate we call, what they would look like, how it would be constructed, how the members would be, and so forth. So if we can get to this convention, I'm just suggesting some reforms, or amendments, if you will, that I think are worth very serious consideration. And as I say in the book, I don't have unassailable knowledge. People will make whatever arguments they want to make. Delegates will say whatever they want to say. The states will do whatever they want to do. So I'm not doing anything utopian anything. In fact, I reject it. But what are these ideas? Now, you know some of them. Some of you who listen every day, you know most of them. What are these ideas? Why are they important? And so what I've done in each chapter, where I make a reform proposal, an amendment proposal, is I tie it back to what the framers said at the Constitutional Convention and at the state ratification conventions to address what's going on today. So it's not just a history lesson, although it's all of that. I tie the history lesson, the information, much of which I doubt you've seen, to what's going on today and suggest a solution. So one of the amendments I would bring to the convention, or I hope somebody would, is an amendment to establish term limits for members of Congress. I had a gentleman come up to me at one of the book signings and say, I don't support this. I know Congressman this guy, and he's a good guy, and I know Congressman that guy. And I thought, this is the problem. Congress sucks, but my congressman's great. Folks, we can't remove the ruling class without removing the ruling class. Section 1 of the term limit proposal for members of Congress. No person may serve more than 12 years as a member of Congress, whether such service is exclusively in the House or the Senate or combined in both houses. Section 2. Some of these have technical aspects. Upon ratification of this article, any incumbent member of Congress whose term exceeds the 12-year limit shall complete the current term, but thereafter shall be ineligible for further service as a member of Congress. Period. The framers believed in rotation, in and out of office. They did not believe in a professional ruling class that had more knowledge than everybody else, because they don't. Otherwise, why did they run up a $17 trillion fiscal debt and a $90 trillion unfunded liability? They don't seem to be so smart to me. So rotation in and out of office is crucial for a representative republic. So we talked about term limits for members of Congress. Now the next proposed reform, or amendment if you will, some people might find controversial, but it's not if you read the chapter. Section 1. The 17th Amendment is hereby repealed. All senators shall be chosen by their state legislatures as prescribed by Article 1. I'm going to explain this. Stay with me. Section 2. This amendment shall not be so construed as to affect the term of any senator chosen before it becomes valid. In other words, if you're there until you're done for that term. Section 3, when vacancies occur in the representation of any state in the Senate for more than 90 days, that is, in the past, some 100 and some years ago, there might be a deadlock in a state legislature. Now, it didn't happen often, but on the rare occasions it did, they'd be without senators. This happened particularly in Delaware for 3 or 4 years. Well, not such a bad idea now that I think about it. But in any event, so if there's a vacancy for more than 90 days, the governor of the state shall appoint an individual to fill the vacancy for the remainder of the term. Section 4. A senator may be removed from office by a 2/3 vote of the state legislature. Mark, what's this all about? It's about unraveling the ruling class. The framers understood that whatever institutions we have and whatever institutions they establish would be imperfect. The framers also understood that the people in these institutions would be imperfect, because that's what people are. So they wanted a matrix of checks and balances, branches of government, and levels of government. Under the Connecticut plan, and you'll learn this when you read it, the bicameral legislature, Congress, a House and a Senate. The House, they decided, should be popular, its members popularly elected, directly elected, and more numerous than the Senate, whose members were to be chosen by state legislatures. And this was another crucial point in convincing some of the teetering states to ratify the Constitution, because the states did not want to be swallowed up by this new federal government, as the anti-federalists insisted they would be. And so the Federalists argued, no, they can't be, because we're going to have this Senate, and this Senate is going to be representative of the state legislatures. So in 1913, in addition to a amendment to the Constitution proposed by Congress to impose a federal income tax, there was another amendment to the Constitution proposed by Congress to eliminate the state legislature's roles in the federal government. And this was the death blow to federalism. The states were supposed to be the buffer between the individual and the federal government. Not so much the Civil War, the 17th Amendment. So that is also being proposed. Now, this one is perhaps one of the ones I like the most. The next reform amendment. An amendment to establish term limits for Supreme Court justices and supermajority legislative override. This means I don't have a single friend left on the Supreme Court. Used to have 1, 2, 3, or 4 of them. Section 1. No person may serve as Chief Justice or Associate Justice of the Supreme Court for more than a combined total of 12 years. Section 2. I won't read you Section 2. It explains how that process would work with 9 justices. Section 3 explains what happens when there's a vacancy. You can check it out yourself. Section 4. Upon 3/5 vote of the House of Representatives and the Senate, Congress may override a majority opinion rendered by the Supreme Court. So it can expunge it from the record. It can't change it, can't rewrite it, can't do those. It can eliminate it. So it could be Obamacare, could be DOMA, could be issues like that. Dred Scott decision, Plessy decision, what have you. And my thinking is simple. Some of the greatest framers were distraught at what the Supreme Court had become in the latter parts of their lives, including Madison, including Jefferson. They were furious. And the concern was that the Supreme Court wasn't the weakest of the 3 branches, so it would overpower the other 2, not to mention the states. And yet, we have this preposterous Obamacare decision that is simply based on a complete fraudulent reading of the Constitution. And we're told that's the way it is. Well, lawlessness shouldn't be rewarded with permanence. Should it? So what's our recourse today? Well, if we listen to the Democrats and the Republicans and the spitballers on the sidelines, there is no recourse. Just deal with it. Deal with what? The healthcare system is going to crumble. So my view, this is just a recent example, so you can touch it and feel it, Obamacare. Why should that be the final word? Why shouldn't the final word be the broader consensus of the American people? Not one justice, but the broader consensus of the American people with 30 states voting to override. That could be the recourse. That should be the final say. Section 5. There's a congressional override. A 3/5 vote as well. And neither of them are subject to presidential veto. Neither of them are subject to litigation or review in any federal or state court. So the courts can't then override, as they did the vote in California, these decisions that are made by the states and Congress and pass judgment on whether the Supreme Court can or cannot rule in a particular case. And this override authority has to be exercised within 24 months from the date the Supreme Court renders its majority opinion. As I say, this isn't chiseled in granite, but I think you may find this intriguing. Now, there's a chapter on 2 amendments. This is where the liberals get confused. He's proposed 10 amendments. Actually, there's 11 reform proposals, 2 in one chapter. 2 amendments, and it even says the heading of the chapter, 2 amendments to limit federal spending and taxing. But liberals can't count. And without getting into detail with this reform amendment, it's a severe limit on spending and borrowing, a severe limit on taxing. I tie federal outlays to the percentage of the gross domestic product, cannot exceed 17.5%. I will also move tax day to the Monday before the Tuesday of the federal elections. So the misery that the federal government does to those of us who are still paying federal income taxes is fresh in your mind the next day when you go and you vote. And it should be. Rather than the 7-month and someday separation between the two, which is intentional. Then there's an amendment to limit the federal bureaucracy. If you listen to this program, I call this the fourth branch of government, the administrative state. It is massive. It is out of control. Last year alone, it issued 3,000 laws, which have every bit the legal impact as a federal statute. And in many cases, the president directs his bureaucracy to issue regulations in defiance of Congress and over the head of Congress, where Congress has refused to act, such as cap and trade and global warming and so forth. So-called global warming. So what this reform amendment does is it limits the power of the federal bureaucracy. First of all, it forces Congress to reauthorize in standalone reauthorization bills every 3 years by a majority vote of the House and the Senate, federal departments and agencies, or they expire. So there's a sunset law in place. Section 2, all executive branch regulations exceeding an economic burden of $100 million, as determined jointly by the Government Accountability Office and the Congressional Budget Office, shall be submitted to a permanent joint committee of Congress, hereafter the Congressional Delegation Oversight Committee, for review and approval prior to their implementation. So Congress has unconstitutionally delegated all this legislative lawmaking activity to these massive bureaucracies in the executive branch. So we have the executive branch executing, enforcing, and legislating. Well, it's very difficult to completely reverse that. But what I say is $100 million determination, it goes back to Congress, this permanent joint committee of Congress. And in order to get around all the filibuster rules and everything else, this committee will consist of 7 members of the House, 4 chosen by the Speaker, 3 by the Majority Leader, 7 members of the Senate, 4 chosen by the Majority Leader, 3 chosen by the Minority Leader. No member can serve more than 3-year term, 1 3-year term, and that's so the lobbyists can't get their hands on them for 10 or 20 years or 12 years. And the committee has no more than 6 months from the date of the submission of the regulation to the committee to act. And it can't change the regulation. It either approves it or disapproves it. And if it doesn't act in 6 months, it's automatically disapproved. Got a few more I think might interest you too. Again, notice the theme is to address the concentration of power in Washington, in the different branches of the federal government. It addresses the governing masterminds and the ruling class who are ruling on top of the American people. And it's moving the ultimate decision-making authority to where it belongs. One of the reform amendments seeks to promote free enterprise, private property rights. The framers strongly believed in this. Section 1. Congress's power to regulate commerce is not a plenary or general grant of power to the federal government to regulate and control economic activity, but a specific grant of power limited to preventing states from impeding commerce and trade between and among the several states. So in other words, this addresses the abuse of the Commerce Clause, which has been turned really into, it almost looks like John Kerry's face. It's unimaginable. It's contorted. And it's been used not to promote commerce and trade, but to promote big government and regulations. Well, that's absurd. Section 2. Congress's power to regulate commerce does not extend to activity within a state, whether or not it affects interstate commerce, nor does it extend to compelling an individual or entity to participate in commerce or trade. So enough of this nonsense about non-commerce is commerce, inactivity is activity. Next reform amendment, an amendment to protect private property. Section 1, the only section. When any governmental entity acts not to secure a private property right against actions that injure property owners, in other words, and I've mentioned this, if you live on a river, this is just one of a zillion examples, and you're downriver, and the guy upriver is pouring oil into the river, and that affects your property, of course the government has the power to prevent that. So the government has the power to protect private property. So when any governmental entity acts not to secure a private property right against actions that injure property owners, but to take for a public use from a property owner by actual seizure or through regulation, which taking results in a market value reduction of the property, interference with the use of the property, or a financial loss to the property owner exceeding $10,000, the government shall compensate fully said property owner for such losses. Right now, 99.9% of the time, the government does not, and the courts have upheld that. It's absurd. The next to last reform amendment, an amendment to grant the states authority to directly amend the Constitution. Now, I figure this, ladies and gentlemen. If 5 justices on the court can directly amend the Constitution, then the states, with a supermajority, should be able to address it. Section 1. The state legislatures, whenever 2/3 shall deem it necessary, may adopt amendments to the Constitution. Section 2. Each state legislature adopting said amendments must adopt amendments identical in subject and wording to the other state legislatures. So there would obviously be significant consultation in advance, because we can't have different amendments being proposed as the same amendment. Section 3. A 6-year time limit is placed on the adoption of an amendment, starting from the date said amendment is adopted by the first state legislature. Each state legislature adopting said amendment shall provide an exact copy of the adopted amendment, along with an affidavit signed and dated by the Speaker of the state legislature. Now, this is a little technical. To the Archivist of the United States within 15 calendar days of its adoption. See, I'm trying to make this as ironclad as possible. Section 4. Upon adoption of an amendment, a state legislature may not rescind the amendment or modify it during the 6-year period in which the amendment is under consideration by the several state legislatures. There needs to be finality. An amendment to grant the states authority to check Congress. This is I believe it's the next to last reform amendment. Told you I'd get through them. And each one has the arguments, the scholarship, the history behind them. Each one is a chapter to explain why I believe the framers would endorse this. There shall be a minimum of 30 days between the engrossing of a bill or resolution, including amendments. Engrossing meaning the public presentation of a bill, and its final passage by both houses of Congress. During the engrossment period, the bill or resolution shall be placed on the public record, and there shall be no changes to the final bill or resolution. I borrowed this from Thomas Jefferson, who said it should be a 1-year period. So in other words, when they pass a bill, both houses of Congress, amend it, whatever they do, before it becomes law, it must sit publicly for 30 days. So you and I have time to digest it. Section 1, this is Section 2. Section 1 may be overridden by 2/3 vote of members of each House of Congress. That's in case of an emergency, a war, something of that sort. Section 3, upon 3/5 vote of the state legislatures, the states may override a federal statute. like Obamacare. Section 4. Upon 3/5 vote of the state legislatures, without reading it all, the states have the power to override. Remember those regulations I talked about exceeding $100 million? They have the power to override that regulation that's adopted by Congress. Section 5. The state's override shall not be the subject of litigation or review in any federal or state court or oversight or interference by Congress or the President. As you see, I'm not giving them an out. And this override authority, by the way, has to be exercised no later than 24 months from the date the President has signed the statute into law or Congress has approved the final regulation. I think you'll find the discussion behind each one of these reform amendments very, very interesting, bracing, in fact. The final, the 11th Amendment. An amendment to protect the vote. Section 1. Citizens in every state, territory, and the District of Columbia shall produce valid photographic identification documents demonstrating evidence of their citizenship issued by the state government for the state in which the voter resides as a prerequisite for registering to vote and voting in any primary or general election for President, Vice President, and members of Congress. Section 2. Provisions shall be made by the state legislatures to provide such citizen-designated photographic identification documents at no cost to individuals unable to afford fees associated with acquiring such documents. Section 3. Early voting in any general election for President, Vice President, and members of Congress shall not be held more than 30 calendar days prior to the national day of election, except for active duty military personnel for whom early voting shall not commence more than 45 calendar days prior to the national day of election. Then I have a couple other sections, Section 4 and Section 5, that deals with the policing of the process to prevent fraud. So that's the amendment to protect the vote. All of them obviously would require 3/4 ratification by the states. If you look at this book, The Liberty Amendments, Restoring the American Republic, you will see that although the specific proposals do not come from the framers, the ideas come from the framers. And that's how I defend each and every one of them. So we're talking about two things. The state convention process for proposing amendments to all the states, as opposed to Congress proposing amendments to all the states. And then we're talking about what it is that should be proposed at such a convention. Now, the fact of the matter is, I believe sincerely that conditions will be created, not by us, but conditions will be created where more and more people will wake up to the fact that the central government is coercive and growing more so every year. Yes, even people who right now are disbelievers or inattentive, they will learn that they're being devoured too. They will learn because they will be directly affected by Obamacare. They will be directly affected by inflation. Their children will be directly affected by what the federal government does. And things could turn ugly. Hopefully not, but they could. That's what happens when an economy collapses and a society is stressed to the point of breaking. The framers were aware of this, and you're aware of this. As I explain in the book, the more desperate the times become, the more aggressive the federal government will become. The more money it needs for its gluttonous, insatiable appetite, the more of your liberties will be seized.